Hello, sir. Hello, sir. Your voice is not audible. Hello, sir. There is some technical problem here. Uh, we can't hear you, sir.
Sir, muted, sir.
So your speaker is off. Your speaker is off.
Now audible?
Yes, sir. Yes,
Yes,
sir.
sir, you are audible.
Okay, good. Please start the program.
Good morning, all respected teachers and everyone who had joined us today. Today, the Shikshan Sanstha Ismailsaheb Mulla Law College Satara organizes one-day interlead collegiate workshop on research methodology. Research methodology means different methods in which a research can be conducted by a researcher. Today we feel honored to have with us honorable guest Dr. Dilip Ukey sir, who is currently a Vice Chancellor of Maharashtra National Law University, Mumbai. Now I requested to our principal Dr. Deepa Patil ma'am to give our chief guest a welcome address.
Thank you.
Over to you, ma'am.
Thank you. Uh, Ismailsaheb Mulla Law College Satara has organized one-day intercollegiate online workshop on research methodology. So I welcome all the students from our college, the students from the other 7 colleges affiliated to Shivaji University. I welcome all the dignitaries for this program. Respected Honorable Dr. Dilip Ukey sir, Vice Chancellor, Maharashtra National Law University, Mumbai. I feel it is my privilege that sir had agreed, in spite of his busy schedule, he had agreed and he is with us to guide us on research methodology. So this subject is very important to all the students from all the strata, but I feel it is more important to the law students. At for their profession, it is the requirement that they have to be aware and they have to inculcate the skills of research methodology, which will be fruitful for them for their future endeavors. So I welcome you all in this one-day interleave online workshop on research methodology. Once again, thank you. Over to Advocate Amit Dravid. Thank you.
Good morning, everyone. I welcome all the participants, all the honorable principals, teachers, students who are joined to this very wonderful event. Uh, we are very honored to have our chief guest, Dr. Dilip Ukey sir. We are very fortunate to hear you from sir. I am here to introduce our chief guest, Professor Dr. Dilip Ukey sir is Vice Chancellor of Maharashtra National Law University, Mumbai. Before joining MLLU Mumbai, he served as a Pro Vice Chancellor and briefly as the Acting Vice Chancellor of SRTM University Nanded, Maharashtra, and Professor and Head of the Department at Department of Law, Pune University. He has also served on national bodies like UGC, NAT, UPSC,
Good morning.
State Public Service Commission, in Uttar Pradesh, Uttarakhand, Orissa, Bihar, Madhya Pradesh, etc., including judges selection panels. He is also a nominated member of UGC panel Hong Kong. In 2019, Sir was conferred the Best Academician in Law by Indian National Bar Association, New Delhi. He is an erudite expert in jurisprudence, constitutional law, and administrative law, and his work in these fields are recognized in national and international fora. His research papers and the recent book on jurisprudence on legal theory is widely read in academic circle. I welcome sir, and without wasting any time, I request Honorable Dr. Ukey sir to guide us on the very important subject, that is research methodology. Thank you, sir.
Thank you, Advocate Amit. I hope I am audible.
Yes, sir. Yes, sir.
So, Dr. Deepa Patil, in charge principal of Ismail Mulla Law College, Satara, Dr. Manjusha, and other faculty members of Ismail Mulla Law College and other law colleges, as well as dear student friends. Indeed, it is a great pleasure and privilege to be with all of you today, though on online mode, to speak about research methodology. It is because of some overlapping, we could not finalize the proper date and time because I have to go for another program and meeting. That's why on my way I joined on road. Otherwise, it would have been a pleasure to be there with all of you physically because physical presence makes the huge difference, not only a difference. Dear friends, when you talk about research methodology, it is such a wide and broader one that which aspect we shall talk about. First and foremost, we need to understand that it is research, whether you do it in the form of your research papers or your dissertation or your
Hello,
publication
hello.
of your book or your PhD. Since it is a research, it is not the search. Generally, what happens that we go on searching and then incorporate those things in our either paper or a dissertation or a PhD or a book, then it ceases to be the research. Research is that whatever you have searched, again therefrom you need to research again in a way, by way of an analysis, by way of an interpretation, by way of an explanation, by way of an exploring the things which are there content in. In view of this, research is that it is an act of searching into all the matters very, very closely and very, very carefully. Moreover, we being the law students, legal research becomes more important one. When you talk about the legal research, I believe that all who have joined are law students and law teachers. Therefore, legal research is what? The legal research is nothing but a kind of a systematic study or it is a study or investigation in existing facts as well as the knowledge. For example, we must understand what we say. When it is said that legal research is nothing but systematic study or investigation in existing facts as well as knowledge. Herein, for example, all of us know well, being law students, Article 21 of the Indian Constitution, which provides the right to life and personal liberty to all the persons. In view of this, as Article 21 is at present, no person shall be deprived from his right to life and personal liberty except according to procedure established by law. As we know well, I did not have to go in all the details. The terminology, the procedure established by law, is it the same today after Maneka, or whether it has undergone a change? If it has undergone a change, why it has undergone a change? Why? As we know that it is after Maneka, in Maneka itself, procedure established by law was equated with due process of law. The word due, which was imported from the American Constitution of the Fifth Amendment, where it says no person shall be deprived from his right to life, liberty, and estate without due process of law. That notion of due has been incorporated, imported, and incorporated into Article 21 of the Indian Constitution. So, unless we now, either when we study, write, or speak anything about Article 21, we shall incorporate, we shall use the term in a careful manner, in a close manner, and that's why the procedure established by law essentially means due procedure established by law. It is a substantive due process in a way that law shall be just, reasonable, and fair, as well as it is procedural due process in a way that procedure which is to be adopted to deprive a person from his right to life and personal liberty shall also be due, shall also be just, reasonable, and fair. And that's how there are various aspects. Of course, we can go on giving examples of each and every facet of it. Therefore, legal research is a systematic study or investigation in existing facts as well as knowledge. For what? There is an object. For what? With the object of finding some truth or reality. What is the reality today? Reality is that Article 21 is not the same. Procedure established by law is not the same contained in Article 21. But rather, procedure established by law means, as it was held so, interpreted so, analyzed by the Supreme Court in Maneka Gandhi. Because that is the law within the meaning of Article 141. As Article 141 of the Constitution says that law declared by the Supreme Court shall be binding. I do not wish to go into the domain of doctrine of precedent and that authoritativeness or the bindingness. And that's what is the object? Object of legal research. The object of legal research is to find some truth or reality. In view of this, the legal research, as I said, that systematic study of then legal principles, rules, due process is the principle, rules, concepts, theories, doctrines, cases, problems, or issues, or combination of all of them or some of them. It shows that legal research involves the investigation and inquiry of not only the provisions but also the principles. As I said, due process is the principle, due is the principle, fairness is the principle, or concepts. Say, like a concept of secularism, it is a concept, or theories, or doctrines, cases, decisions, problems, issues, or combination of all of them. Before I proceed further, let me add the caution that I do not know since I'm traveling at what time, what at what point of time the connectivity may go off. So please bear with me till then. We can talk about it. So therefore, legal research is this. It is a systematic study of all these principles, rules, provisions, etc., etc. Dear friends, before I refer to objectives of legal research as well as the methodology, we must understand that there are the steps and stages of research, and particularly the legal research. I do not know whether there are PhD students even herein in this or even otherwise. law faculty, that first and foremost, formulation of the problem is very, very necessary. What problem you want to investigate? Why? Because as we have said that it is a systematic study or investigation. What do you want to investigate? What do you want to inquire? Hence, that problem is to be formulated properly. Formulation of a problem or before formulation of the problem, identification of the issue or identification of the problem is very, very necessary. Is very, very necessary. So identify the issue or identify the problem first. Having identified the problem, then formulate that problem properly, and then thereafter, generally we do not pay the much of the attention or do not take much of the care about the finalization of title. Finalization of title is very, very essential because title shall be such that we shall reflect the content which would be there or which is there in your research, either in the form of your research paper or in the form of book or in the form of dissertation or PhD, whatsoever it is. Generally, generally we give title without understanding the significance or relevance or importance of the title. Generally, people say, what is there in the name? But there is so much in the name. That's why finalizing the title carry out. That is one. And then the research
Yes, sir.
plan
You
or
are
research
audible.
design,
Yes.
which is, pardon?
Yes, sir. You are audible. There is some glitch in audio uh,
Okay,
because travel. Yes.
that will happen. That will happen because I'm crossing from one side to another part of the Mumbai. So that's why range would be a problem. So in view of this, then it is necessary to devise your research plan properly. That in research plan, then first and foremost, the thing comes that objectives. What are the objectives for which you want to conduct that particular research? When we write an objective, I have seen in some cases they give certain question mark also. How it would be proper to give a question mark in an objective? Objective has to begin with the word to. Say, for example, to ascertain to ascertain the nature, purpose, or policy objective of that particular legal research. I'm talking in general. I'm not talking of the specific title or specific area in which you want to do your legal research. Or other objective could be to examine legal principles and precedents, or to examine concepts, ideas, notions, theories of that particular issue or that particular problem. In view of this, it is necessary to point out what are the objectives of your particular research. Similarly, the objective would be to identify the drawbacks, weaknesses, or defects in the existing law or existing principle or existing theories, so on and so forth. So there could be various such objectives. First and foremost, we must ensure that we must know that there cannot be a question mark in the objective because I've seen such instances even in case of PhD. Here, hence, it is necessary to know, it is necessary to understand. Objective shall begin, objective of the research shall begin with the word to ascertain, to identify, to find out, to investigate, to inquire, likewise. So objectives are very important one because that set, those objectives set ultimately the path and the goal in which you can proceed about your legal research. Similarly, then, as I said, that identifying the problem, identifying the issue is very necessary. What is your research problem? Once you identify your research problem, then you need to decide about what kind of methodology you want to adopt. As there are two types of research, one is doctrinal research, another one is non-doctrinal research. Doctrinal research is also called as theoretical research or armchair research, which is essentially a library-based study, library-based research. That is the doctrinal research. Other one is non-doctrinal, or it is also called as socio-legal research, wherein one has to see the law in operation, law in function, how law operates, law in action, law not only on paper, but law in action in that context. How law operates in social context. That's why it is a social legal research, or that's why it is non-doctrinal research. Non-doctrinal research, wherein not only the rules, not only the principles, not only the doctrines, but even the social facts would be investigated. Even the problems would be investigated, which are social in nature, wherein one can use the tools of data collection. We'll talk a little about that for some time. So there are two types of research. One is research, doctrinal research, which is essentially a library-based research. Other one is non-doctrinal research, which is the kind of the empirical research, which is also called as empirical research, wherein one can collect the data after investigating the facts and circumstances circulating. So, social legal research is also a kind of a systematic study into social, political, economic, or other facts or conditions which exist in a society. Simultaneously, it could be an attempt to ascertain why and how human beings behave in a certain way. Just say, for example, hypothetically, that criminality is more in, say, for example, in in a slum. Suppose we formulate this problem. So one can go there, one can observe. Of course, there are several tools of data collections, and then identify why human beings behave in a certain way, in a particular way. And that's why rather then the hypothesis come. This is a kind of an hypothesis. This is the kind of identification of the issue. That to identify the cause as well as the effect of a certain problem. The problem which we have referred, that criminality is more in slums, for example, hypothetically. Tested them on the basis of the data which will be collected, whichever way, then this hypothesis could be tested. That is what the empirical research, that is what the non-doctrinal research is all about. Because socio-legal research, it is an effort to uncover actual realities or truths which exist in a society. What are really those realities? What are those facts? What are those truths which exist?
Uh, Sorry, sir. It is requested all the participants to mute their phones. Thanks. Yes, sir.
So whenever the research is the empirical, then tools of data collection are used, which become very, very important, which become very, very necessary also. Because why empirical research is necessary, I will appeal and encourage all of you to go for empirical research because it uncovers even unknown facts. Say, for example, it is a myth, it is an illusion that the sex determination and removal of fetuses is the practice which is existing or which exists mostly in a poor class. It may not be so. If one conducts the empirical research, looking at the realities, truths which exist, social realities and truths which exist, it could be otherwise. It could exist more rampantly in a well-educated class, rich class. Who knows? That's why social legal research uncovers the unknown facts or supports or contradicts even those facts. Like say the example which you have taken. Moreover, it provides. They shall be muted properly. Hello.
Ah, yes, sir.
Ah,
Yes, sir. That problem has been taken care of.
okay. So, in view of this, it is necessary that the empirical research which brings out the social realities, social truths which exist, which may contradict the perceptions, which may contradict the existing knowledge or existing assessment which we have. That's why empirical research is more important as such. Similarly, either when you finalize the title or chapterization, somewhere we use analytical study, somewhere we use critical study, we shall know the meaning of the word, then only we shall employ those words. Analytical study involves the careful examination and evaluation of something in order to understand or explain or draw inferences in a confusion. That is a kind of analysis, analytical study. Whereas in case of critical study, mostly similar to analytical, except the researcher carefully ought to point out inadequacies, drawbacks, or disadvantages, and then he shall express his or her own opinion about those disadvantages or drawbacks. Somewhere we use the comparative study, comparison with whom and comparison to what extent, that is also we must understand. The other thing is that generally, as I said, that research methodology, somewhere some people use the term research method. Two things are a different one. Research methods are different one. Research methodology is different one. Methodology is a broader in scope and wider, wherein research methods may be the part of research methodology in conducting the legal research. So, for example, doctrinal method, research methodology, or non-doctrinal one, wherein suppose it is a empirical one, whether when it is a non-doctrinal one, it is necessary, it is essential to formulate the hypothesis. Dear friends, again, I would urge and say at this juncture that whenever we formulate the hypothesis, there shall not hypothesis cannot be in the form of question. That is one. Because in some instances, again, I would say that there were the questions in hypothesis. You can have research questions differently. Research questions are different than the hypothesis. Hypothesis is the proposition. It is just a proposition which may be proved true or maybe may not be proved true. Say, for example, that's what we say hypothetically. It is an imagination. Women lawyers are more successful in Satara district than men lawyers, or women law teachers are more successful than male law teachers in Satara district. This is the hypothesis. You can conduct a survey, but there cannot be the question mark. Once you put the question mark, it ceases to be the hypothesis. That is one. Secondly, there is also a wrong impression or wrong understanding that there has to be only one hypothesis. No, there could be more than one hypothesis. In such situation, we may call that hypothesis, multiple one, plural one. So it is not essential, it is not necessary to have only one hypothesis. Another thing is that hypothesis shall be crisp. They shall not run in sentences to sentences. They shall be formulated very properly and in a crisp manner. Because hypothesis is what? Hypothesis is an unproven proposition, as we referred this to, that either women lawyers are more successful than their male counterparts in Satara district, or women law teachers are more better than their male counterparts in Satara district. So this is a unproven proposition. It is just a guess, and after the data collection and analysis, then one can reach to the conclusion whether it is true or whether it is not. That is also one facet or one aspect of it. Another essential component of research methodology and legal research or otherwise research is literature review. By and large, what we have observed that people take literature review very, very lightly, very, very casually. It should not be so. Literature review is what? Literature review is a survey of published or unpublished work. What aspects in proposed research they have to be covered, one need to know. And then what remains uncovered, that's what the literature review is necessary. It literature review enables the researcher to learn from others. Suppose you choose any particular area, the PCP&DT area. Therein, in that particular area, what are the literatures which are available? Whatever the literature is available, then what remains to be explored, that one can decide. Wherein proper literature review reveals, identifies what type of studies have been done and whether current research will add something into that. And that's how the literature review is important one. Moreover, literature review doesn't mean to just provide the list of books or list of authors. There are the components of literature review. In literature review, proper literature review, the introduction is to be given first, then thereafter some main bodies to be given, whatever you refer to, and then certain summaries or contribution, or in the form of some conclusion in literature review, it is to be provided. Because literature review is an essential component of any legal research, particularly the empirical research, as well as the doctrinal also. In view of this, now we shall come to the data collection and tools of data collection. Because I am reaching, I will just take 5 minutes and then we'll stop. Particularly in case of the empirical research or non-doctrinal research, as we call, there are several tools of data collection. One is observation. the researcher need to go there because observation provides scientific approach to that particular research. Say, for example, scientists, astronomers, physicists, they use this observation method. Therein, one feature of observation is participant observation. In case of participant observation, researcher mixes with the people. He or she get involved in the actual life of the people there, be it a factory or be it a village or a family. He participates in those affairs and then come to know the facts, then come to know the realities. That is participant observation. Another one is non-participant observation. He doesn't take part. He merely observes from the distance. That's all. What are the advantages? Advantages of this tool of observation is that data can be quickly obtained because it is for you to go there and observe. Then in some cases that might prove to be wrong. Just hello. Good morning, madam. Reaching in few minutes. Yes, 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 yes. Uh, Sorry. Then observation is one because we need to close. The other tool is interviews. One can take the interview. One can go and take the interview. One can interview the people there. Third one is questionnaire. You can circulate the questionnaire and then you can seek the responses. There are you can draw the samples because of the paucity of time, because this area is such a vast one. There are various facets. Even the tools of data collection, there are several things. Each tool requires some time. So one can circulate the questionnaire. While preparing the questionnaire, one need to take very much precaution that those questions shall not be the leading questions, as well as shall not wherein the data can you can
Hello, sir.
obtain
There must be some network connection problem.
the
Hello, sir.
data.
You are not audible, sir.
Right. Whatever your conclusions are drawn based on your analysis. Hello.
Yes, sir. You are
Hello.
audible now. Yes, sir.
Uh, since when I was not audible?
Yes. Now you are audible, sir. Yes. Yes.
So we need to stop now.
No, sir. Actually, you can continue this point.
We need to stop because I'm reaching my
Okay.
destination.
Okay, sir. Okay, sir.
Mhm. Hmm?
Okay, sir.
All right.
Okay, sir. Okay, sir.
Okay, fine.
So thank you, sir, for giving us all the points relating research methodology from initiation, that is from framing the research problem to hypothesis, data collection, data analysis, and very short time you have explained all the terms that are in the research methodology to all the participants who are joined to this event. Now I request Desai sir to give vote of thanks, and I also personally request Honorable Dr. Deepa Patil ma'am to kindly invite Dr. Ukey sir to our college so that we can have the offline conversation with him, and we are very fortunate to hear you from sir. Over to Desai sir.
Thank you, Dravid sir. It's very great pleasure to hear Dr. Ukey sir, as most of our faculty, most of my friends, they are directly students of Dr. Ukey sir, and it is always opportunity for all the teachers as well to hear Dr. Ukey sir and to take the guidance from the sir. Sir has deeply informed us about all the aspects of research methodology and also guided on how to make a research in a fruitful manner. Despite of his busy schedule, Sir has given us valuable time and given us the inputs regarding the research. So I, on behalf of Ismailsaheb Mulla Law College and all my students, I would like to extend heartiest thanks to Dr. Ukey sir for their valuable guidance, their presence, and sparing time for us. Thank you very much, sir. Now, I would like to extend my gratitudes to uh, Principal Dr. Deepa Patil ma'am, that she has taken the initiatives to organize such type of activity. I also like to express my thanks to Advocate Amit Dravid sir, PD Zadav sir. They have organized this activity for the law students. I also like to express gratitude to all the teaching, non-teaching staff, and all the students present over here for their patience hearing. So thank you one and all, and thank you very much.
Okay, thank you, sir. Now I request all the participants to turn on the camera so that we have the snap of this event. Yes, thank you very much. Now I conclude that this program is over. Thank you all the participants for joining this event. Thank you.